Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item number 6, Your Lordship.
Yes, who is the other side?
Lordship, no objection, Your Lordship.
Yes, what do you want?
After 2 weeks, Your Lordship.
What's the matter about this one?
Parity in pay, Your Lordship.
6 as a request of the petitioner, and this is a matter after 2 weeks. Yes.
Deeply obliged.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 5. Kindly let this matter come after 2 weeks.
5 also, same, at the request of the petition, list after 2 weeks. Yes.
I beg to mention item 10, my lord. Item 10 and item 13. These are those quashing of the
Well,
POXO proceedings.
let us go one by one. 10 and 13.
My lord.
10 you are for?
For the petitioner, my lord. This is regarding the quashing.
Who is
of
the
the
other side?
Yes.
Yes, this is regarding quashing.
My lord, I'm praying after 2 weeks.
Item 10,
My lord.
Yes.
10,
10?
13, Lordship.
Wait, just 10, Mr. 10, is appearance of the state.
My Lord.
Yes. No objection.
My Lord.
10 also, same order. And 13?
No objection, Lord.
13 also you are for the petitioner.
my lord.
Same order. Same order. Yes. 2 weeks or the request of the petitioner. Yes.
Please, Your Lordship, item number 12 is also connected to subject matter same as item number 11 and 13. 12 is also for quashing. This is a POXO related matter, Your Lordship.
Item
12, Your Lordship.
you're
Main
making,
list.
yes, you're making mention of.
I'm for the petition.
So it is related to.
Yes,
what?
Your Lordship.
It is.
It's the same as item number 11 and 13, quashing, Your Lordship,
I'm
in
making a
POXO.
mention for item number 11, Your Lordship.
Same as means like. what is the
Lordship,
relation
with
between
regards to the compromise in POXO matters, Lordship.
that is pending before the
Lord.
division watch. So 11 and 12 both are same.
Yes, Your Lordship.
So
Similar
we'll have it
matter,
after 3
issues.
weeks then.
Lordship.
Yes, Your Lordship.
Is it all right?
Lord.
Yes. 12, 13 the request made by the parties. List is matter after 3 weeks. 3 weeks? All right. Yes. Oh, not 12.
Obliged, Your Lordship.
11 and 12. Yes. Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 8, Your Lordship. I've taken the consent of the other side. May it come after 2 weeks, Your Lordship. No objection, Lordship.
You're appearing for?
I'm for
Private
respondent number 5 and 6, Your Lordship. 5 and 6.
Who is state? Who is appearing for the state? Item 8? You are there. What is the matter about, madam? This is?
Your Lordship is relating to POXO quashing, Your Lordship.
This is POXO quashing. On what ground?
Your Lordship.
None of you know the case.
Your Lordship, in this matter, we are going for compromisation, Your Lordship.
Compromise. So that is again the same issue.
Same issue, Your Lordship.
So that is also at the request. Yes. Any problem? The court is dictating order and then you are looking other side. This item 8. This also will be at the request made with the parties, list after 3 weeks.
Your Lordship, similar player for item 9 also, Your Lordship.
Item 9, is it same thing, quashing on compromise?
Yes, Your Lordship.
That is also same thing. The husband wife or romantic relationship, what? But then that is on.
Your Lordship, regarding compromise, I have not gotten any instructions.
No. Is this a case you are seeking quashing on the basis of a
Yes, Your
compromise?
Lordship.
On the basis of a compromise?
Yes.
In a POXO matter?
Yes.
This also will come up after 3 weeks then. These are related to that issue.
Yes. Yes. Sure.
Be sure, because it appears that none of you know about the subject matter of the case. Now, until unless you know it, which way the court will know that, which will quote your submission as correct. That is the main thing. And it happened on the earlier occasion, we have recorded wrong order on the basis of the submission of the counsel's appeal. So at least read your brief before you come. And it should not be something like that, when courts ask you about the fact and you just suddenly see all of a sudden you look helpless and then see, like, it should not be something like that. 9 also 3 weeks at the request of the petitioners. That's the request made by on joint request of the parties. This is a matter of proceedings. Yes.
Any objection?
Please, Your Lordship, I beg
Yes.
to mention item number 7, Your Lordship.
Yes.
Your Lordship, I pray for 2 weeks' time, Your Lordship.
You are appearing for the petitioner here.
Yes, Your Lordship.
No objection. This is the case which was pending for compromise.
Yes,
Yes,
Your
Your
Lordship.
Till now, no news.
Lordship.
Okay, 7. At the request of the petitioner, listed for 2 weeks. Yes.
Obliged, Lordship. Supplementary causes, item number 1.
May it please, Lordship, my apologies. Lordship, I beg to mention item number 4, Lordship.
Yes.
Lordship, may I have it after 2 weeks, Lordship?
Why? Why after 2 weeks?
Lordship, there's some difficulties with this matter, Lordship. I still have to study a bit.
No objection, my lord.
What is the matter, Mr. Pante?
Even I am handicapped, my lord. My colleague is falling with them. I'm extremely sorry, my lord. My apology, my lord.
Made on behalf of the state respondents, list this matter after 2 weeks.
I do oblige.
Apology.
May it please Your Lordship. Lordship, I humbly pray if this matter may be taken up at the end of the vote, Your
What is
Lordship.
this matter?
My lord, this was dismissed for default. My
This
lord,
is
due to-
restoration application.
my lord,
When this matter was dismissed?
on 8th of August, my lord.
Yes, this is very recently then. What is the problem?
Your Lordship, the DHR has got some important submission to be made before this court, Your Lordship.
Important submission.
Yes,
What
Your
is that important submission?
Your Lordship, I have
What can be an important submission in this thing with this restoration application which was dismissed for default of appearance of the petitioner?
Your Lordship, he hasn't been instructed, Your Lordship.
This is only mere reopening the matter. What is the thing? It's a restoration of the matter only. Yes, only because there is on the 2 consecutive occasions.
Because of the fault of counsel, my lord, it's me on the medical treatment of the eyes.
So do you think? Okay, then you pay cost. If it is your fault, then you have to.
My lord, I
You can understand that you were out if you are there, but then somebody should have been deputed to make a mention. At least it should not be something like that. That you see matter go unrepresented.
no, my lord.
Not a good thing for lawyers.
I agree, Your Lordship, but I humbly pray, Your Lordship, if this matter may be taken up at the end of the vote, Your Lordship.
When?
At the end of the vote, Your
At
Lordship.
the end of the vote.
Yes, Your Lordship.
Okay.
Much obliged, Your Lordship.
Daily cause list, item number 1.
Yes.
Item number 2.
Yes.
Your Lordship, we have already done this this affidavit report, service report, and last occasion Your Lordship has recorded.
Yes.
It
Nobody
seems-
appears for this.
My apologies, my lord. Here, Miss R. Kulni, my lord, she's probably on legs in the DB. my lord.
See, this is probably is one thing. You
No,
see,
no,
that
I am
this is a
representing her
matter,
today,
this
my lord.
listed cause list comes out before it is. It is not that this matter is suddenly. Please take care.
My lord. So I'm
It
appearing
is
on
not
her
that
behalf.
that in the panel you are the only one person.
That is them.
See, if this thing goes like this, then court will pass. You see, like do not. You are compelling the court to become harsh.
My lord, my apologies. I'm appearing on her behalf.
So what is to be done?
Lordship, service to the.
Yes, that is all right.
Yes,
That is all right. We
completely.
got it. Service is there. None appears for the response
Yes,
number 2, isn't it? Now, what is to be done today then?
Uh,
Are you
Lordship,
ready for the matter? For
Lordship, let this come for the hearing straight away because despite of service notice, the private respondent has
yes,
failed to
then
appear.
there is no there is no this thing objection. There is no requirement of filing of objection by the state.
No, no, sir.
There's a criminal petition allowed.
Let this come for the hearing, Lordship.
Ready for hearing, matter is
Let
ready
it
for
come
hearing.
up for hearing, my lord. I'll inform the concerned council, my lord.
Are you sure that matter can go for hearing without filing any objection or anything?
My lord,
Of course,
it
there
may
is
be
no prayer.
posted.
There is no prayer on behalf of the state to
My
file.
lord. My lord, it may be posted for hearing. In the meantime, my lord, if there is objection, it will be
We will
filed.
not pass any order. That will remain. We will just see it first. Mr. You are Mr.
G. Yobin, Lordship.
G. Yovin. So that is a difficult P. Yovin, G. Yovin. Mr. G. Yovin, Learned Counsel is present for the petitioner. Also, I had Mr. G. Yovin, Learned Counsel, the petitioner, and also Mr. Ketni Bhattacharya, Learned GA for the respondent number 1. Stop. None appears for the respondent number 2. It is submitted by the parties. That matter is ready for hearing. Stop. Accordingly, list this matter for hearing after 2 weeks.
Obliged, my lord.
Obliged, Lordship.
Hearing item number 3.
Yes.
But here the petitioner counsel is also not there. Matter may come up after a week.
None appears for the petitioner. Mr. So-and-so and Mr. So-and-so present on behalf of the respondent. Number so-and-so and so-and-so. List this matter after 2 weeks.
Malad.
Consecutive to appearance, matter will be dismissed.
Malad.
To non-appearance, there will be.
Obliged.
Item number 14.
Yes. Yes, Mr. Kharwala.
May please your lordship.
Yes.
Lordship, as on the date order dated 4 July 2024, lordship. Lordship had recorded that service was already effected on the private spot.
7.
Yes, lordship. Oh, sorry. Oh, my lordship, my apologies.
Yes.
May please, lordship. My apologies, lordship. I'm mistaken with the other matter. Lordship, the arguing counsel, Mr. Andy Shula, is before the division bench, lordship. If the matter may be taken up on the next year, lordship.
What is the matter about?
This matter, lordship, stated file an application for recalling witness before a trial court.
It was
Agreed by that order they filed.
Trial court rejected it.
311 application, lordship.
Then what is the ground for rejection?
Ground for rejection, lordship, is because of pendency of trial. Trial has been pending for more than 10 years.
14. Yes, Mr. Shula.
Just get the file. Just a minute. I'm sorry. File. Lordship, this is a petition under 482, Your Lordship, challenging the order passed by the learned section judge, Your Lordship.
You are ready. Parties are ready for hearing. Ready.
Ready, lordship.
Lordship, kindly have a Lordship, kindly come to page 124, Your Lordship, Annex of 4, Your Lordship.
Page 124.
Lordship, first, kindly come page 1 to 2, Your Lordship. This is the application filed by the state under section 311, Your Lordship, for recalling of certain witnesses.
Yes.
Lordship, kindly come to paragraph 4.
Yes.
These are the name of the witnesses are required to be called, Your Lordship. Then
What is the case? What is the charge in the case?
Lordship, this is under 302, Your Lordship.
It's a 302 case.
Lordship, yes.
And the witnesses who are sought to be recalled are what witness? One is Caesar witness and another?
Lordship, just a minute, please. Lordship, one is magistrate, Your Lordship, who has recorded.
Who has recorded statement of
the witness, Your Lordship.
witness? Which witness?
Lordship.
164 statement.
164 statement, Your Lordship.
Is this a confession statement or is it a statement of the witness?
Just a minute.
Mr. Shula, you will have it tomorrow. You have read your file and you will have it tomorrow.
Lordship.
It seems you are not prepared to.
Not
tomorrow.
tomorrow.
Understand your body.
Tomorrow is Independence Day.
Oh, tomorrow is Independence Day.
Lordship, it comes on 19. Lordship. 19.
19th is all right for you?
Lordship, on 19.
No.
19 is a Monday, Your Lordship.
So we'll have it next week. We'll just say next week.
Next week, Lordship.
1 week, Lordship.
Next week, Your Lordship will have. It's a small issue, Your Lordship. That is.
That is all right, but then it seems you are very slow in responding to the court's thing. Normally you are very fast and fluent.
Lordship, what? I'm sorry, Lordship.
Now, the court could get a presumption that you did not get a chance to refresh your mind.
There were 2 appeal, Your Lordship.
We can understand that. We can understand that. So that is why. Yes, sir. The request
Next week,
made-
Your Lordship,
yes, at the request
certainly
made
I'll
on behalf of the petitioner, list this matter in the next week.
oblige, Your Lordship.
Obliged.
I'm sorry, Your Lordship.
No, it's all right. There is no problem, Mr. Sulai. But then, see, like we also would be happy if you see counsels are prepared. You do not have to look back to your junior every now and then for answering simple questions.
Your Lordship. Highly oblige, Your Lordship.
Item number 50.
Yes.
May please, Your Lordship.
Yes.
Lordship, my apologies. Lordship, this was a matter which I was giving out.
For which you have made advance submission before.
Lordship, my apologies, Lordship.
Yes.
Lordship, may I continue, Lordship?
Yes.
Lordship, as per the order dated 4/7/2024, Lordship.
Yes.
Your Lordship had recorded that notice upon the respondent has already been served on the 5th June 6, 2024, Lordship.
Yes.
And Lordship, after that, Your Lordship, the matter had come up on after for 2 more dates, whereby the respondents have not appeared, Lordship. Thereby, Lordship, I pray this court may list this matter for hearing ex parte, Lordship.
Where is the provision of proceeding ex parte in a criminal case? That is a concept you find in civil law or in maybe in writ petition. But then show us in any provision in CRPC or any other law for ex parte proceeding of a criminal case.
Lordship, then if this matter may hear us,
there must be something, isn't it?
Lordship.
Then
Lordship,
your submission is basically backed by what law? Just tell us. You made a submission for ex parte proceeding in this matter. Now just show us the law in a criminal case where this court can order ex parte proceeding.
I'll try to satisfy, if my lord grants me time, I'll try to satisfy my lordship on that issue on the next day, Lordship.
Anyway, we are ready to move ex parte things. You can start hearing this. You can argue on merit. We'll hear you.
Lordship.
Since none appears, it's all right.
Lordship. Lordship, if since the matter is being led by Senior Counsel Mr. Khal Khan, Lordship.
Mr. So and so GA is present on behalf of the state respondent, on behalf of the petitioner, on behalf of the petitioner or state respondent. There is only one respondent, isn't it, in this case?
Lordship.
None appears for the respondent. None Yes, brother. Stuff on the previous vacation also. There was no representation. Not on the do not say on 19/7/2024 also there was no representation on behalf of the respondent. The London State Council submits that the matter is ready for hearing.
Watch.
Since give a stop. Since next paragraph, since none has entered appearance on behalf of the respondent, despite service of notice, comma, the matter shall proceed for hearing in the absence of the respondent. We will say message shall proceed for in the absence, but we are not saying ex parte.
Lodge.
Meaning thereby, whenever respondent is present, it can take part in the hearing.
Lodge. I know.
Then you got it. Then have you said list for hearing on such a such? Then list for hearing after 2 weeks. The last time. If you have not said it before, if it is said before, the last time is not required. While typing, just take it. Yes.
I do oblige.
Item number 16.
Yes.
Please, Your Worship. This is a petition for quashing, my lord.
Yes. Quashing on the basis of?
On the basis of they have already compromised the matter.
The matter is not compoundable.
Yes. All sections are compoundable except the one on the, because it is fall under Public Premises Act. So that's why that's the thing is not compoundable. Otherwise, everything is compoundable. In this case, all the accused persons also have already signed the compromise.
And anybody representing the accused? Yes, Mr. Sen. So there is a compromise.
There was a first round of all signatures were not there. Now these signatures are compromised.
So there is no technical difficulty now.
Lordship, I think that is kindly come to page 36.
Page
36 of the revision petition, Your Lordship, or of the criminal petition, Your Lordship. Kindly see at serial number 6, Your Lordship.
Yes.
Yeah. Lordship.
Serial number 6, yes.
Lordship.
Roman 6. Yes.
First developing group, Your Lordship.
Yes.
First developing group. Lordship, I did not see his name in the.
He's also an accused.
Is dead?
Is dead.
Okay. Yes, Mr. Shulai, apart from these technicalities, any objection? Any other objection?
Death certificate also is there. Annexure 4, my lord. Page 21. Death certificate is there.
Yes. Page 20.
21, my lord.
Page 21 of your petition. It is a page 21 is a death certificate.
No,
He
no.
died.
To show the death.
Oh. So how many? There are more than one death certificates appended with the red petition. In this page 20 also there is some. This is also there. So how many accused were there initially?
21, 20, 21, 21 is only one. 21 president.
Then
Crime perhaps or not.
21 accused in the matter.
20 is still alive. 21 is dead.
There's a charge sheet against how many?
Against 7 in last time.
Yes, 7 persons.
Yes.
So out of 7, 2 persons have died. Do you want? No. So it means there are 9 persons.
No. 9. Yes, 9.
It has to be something like that.
2 died, 7.
Yes, that is what. So 2 died, 7 remaining. So the charge sheet was against 9 persons. The trial was proceeding against 9 persons.
9 persons.
And what is the stage of the trial now? What is the stage of trial now?
Now stage is for evidence.
Evidence of?
Charge sheet. For charge sheet.
How many witnesses have been examined?
Not yet. Charge sheet.
Only charge sheeted?
Yes.
When it was charge sheeted? What is the decision of that apex court with regard to that this thing?
Ginseng, Your Lordship. I have the judgment.
Yes, Mr. Sulai, any objection?
Lordship, the only objection is that this is a public property, Your Lordship. A public property, whether that has been Lordship, can you see the
Thereafter, after that Jianqing, there 2019 decision was also there. There's a decision in 2019.
They are keeping someone's December.
Yes, Mr. Shen, you have that. Only Jianqing. There is a 2019 decision also.
Lordship, if Lordship kindly come to
Which
page
further
23.
elaborates this. Anyway. Yes, Mr. Kinjin. Yes, sir.
But in
What is the relevant part of this judgment?
Para 58, Your Lordship. 58, that
Is
can
it?
say.
Mr. Kinjing, are you
Exactly
relying on
relevant.
this? No, you have a decision with you.
yes, I have, man.
Yes, you just
Kian Singh versus State Punjab, paragraph 57, my lord.
The same only.
the same thing.
Same only. Yes.
This is 2012-10 SCC. Yes. And you are relying on para 58.
57.
57.
The relevant part of my lord is, however, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Heinous and serious offence of mental depravity or offences like murder, rape, dacoity, etc. cannot be fittingly quashed, even though the victim of the family and offender have settled the dispute. Such offences are not private in nature and have serious impact on society. But then you go on, my lord. But the criminal cases having overwhelmingly and predominantly civil flavor.
You are reading which part?
That 57, the middle part, my lord.
Paragraph 57 of the middle part.
Middle part.
Paragraph 57 is not a.
But the criminal case having overwhelmingly and predominantly civil flavor stand on different footing, and the purpose of questioning partly the offences arising from commercial, financial, mercantile, and civil as such like taxation are offences arising because
Are you reading from SCC?
Yes, my lord.
Why it is different here? Paragraph 57. Your printout is from SCC, Mr. Sulai.
Lordship, yes. This is SEC
How
only.
come,
But is Supreme Court weekly known, my lord?
Oh,
Supreme
this
Court
is
SCW.
AIR SCW, Your Lordship.
SCW.
Yes.
SCW.
So in this case, my lord, the matter is purely civil in nature, and it has been disposed by the aim of Khairim, as well as first among them, then between. Then by the subordinate district council court, Khairim Simship. Canadian waiver. Relevant for the paragraph. 7. Then, my lord, another decision, my lord. It's a criminal. It's from Himachal Pradesh only, of course.
They're not same proposition, isn't it?
Yes, same proposition.
Not a fair.
But that's the thing, my lord. This matter is purely civil in nature and has been settled among themselves. And now there is quite a number of time, quite a number of years has been settled, and they are living peacefully till now. This is a co-villager, my lord. And over and above, prior to that, they have filed a civil case in the district council, and that also they have already withdrawn.
This is a boundary dispute between two villages.
Yes, that's the thing. That's the thing, and that also have been settled. It has been the damages also regarding. It has been withdrawn also, and then has been settled in the court of the district council court, my lord. And that judgment is in
Civil case has been settled. Civil case has been settled.
Yes, yes.
There was a civil matter, and it was this civil case has been settled.
Settled.
Before the occurrence of the incident in this case, or
no.
After
the incident. When did it, page? It is in page 29, my lord. Annexure 8.
Page 29.
This is a civil case between that Umpranai village and they have filed a damage suit, my lord. Page 29, Annexure 8.
So you have paid the damages?
Yes, my lord. That have been settled, my lord.
After payment of damages? After payment of damages, you have settled it. After payment of damages, or it was just like?
Maybe they make payment also, who knows, like that. Yes. Naturally.
So it was disposed of?
Disposed. This one also disposed of.
What is the date of the order? 15th July 2022.
15 July 22.
Yes. And when did you enter into compromise here in this case? What is the date of compromise here in this case?
12 June.
Of?
2023, 23 date 12 June.
Where is your compromise? Which page?
Page 101.
12 June 2024, my lord. 101.
101.
When this complaint was instituted first, when it was filed, lodged?
Lordship, kindly come to page 23. That is the FIR.
2017, my lord. In 2017, FIR was filed. Page 22.
This 21st December 2017. This is a complaint filed by?
By the then headman of Umpranai.
That means Mr. Shan's client.
That's one number 2. The citation we have given from the Himachal Pradesh, my lord,
Yes.
is relating to the same section of that 3 of the public damage property. 3D.
Yes. In which paragraph?
Paragraph 2. Precisely the fact the case as a match from the record as FIR sought to be quashed in instant proceeding came to be lodged at the behest of respondent number 2, who alleged that on 12/12/2014 at about 12:30 p.m. petitioner Simiti so-and-so is working as a clerk in the office of so-and-so, misbehaved and with other fellow colleagues and thereafter caused damage to government property. After completion of the investigation, police presented the challenge in the competent court of law, but before the same could be taken to its logical end, the petitioner entered into compromise with respondent number 2, whereby both parties have resolved to settle the dispute amicably, inter se them, and as such, the petitioner has approached this court in the instant proceeding for quashing FIR as well as the consequent proceeding, if any, pending in the court of competent law, court of law. Okay. Then it comes to paragraph 13 also, my lord. Paragraph 13. Since the matter compromised between the parties and respondent number 2, complainant is no more interested in pursuing the criminal proceeding against the petitioner, no fruitful purpose would be served in case proceeding initiated at the behest of respondent number 2, complainant allowed to continue as such in the petition at hand can be accepted, madam.
See, this observation that no fruitful purpose would be served now is no ground for interfering. That is what the apex court says. These are the latest things. So anyway, it's all right. But then that simple thing that since the complainant is not interested in pursuing the thing they have compromised, and no fruitful purpose would be served, now the apex court says that that cannot be a ground for quashing.
That's true, my lord. But actually, the apex court has given that decision or observation, what we may call it depends on the nature and gravity of the offence, my lord. This is a minor offence compared with those referred by the Honorable Supreme Court, my lord. And that water source is intact, is impeached in completion certificate, another also been closed, my lord. It is page 97 of our petition.
The water source is intact?
Yes.
Intact means it has no damage done to it. Was there is damage done to you? Why?
That has been...
now it is intact.
And that has been repaired.
And it is operating.
Yes, yes. Nobody is suffering. We have given the photograph also here, my lord.
It's all right. Once it is not disputed, it's all right. Photograph is not a primary evidence.
That's true, but actually we have taken it.
We do not know. We have a practice of many things. It happens. But then can we take cognizance of photograph? At least for passing an order. This court has a different view. This is not a primary evidence.
But
anyway,
that's true. Right. But you have based on affidavit also, my lord, whatever we have stated.
It's all right. It's all right. Yes, Mr. Sulai.
Lordship,
should not be any this thing. Let the villagers live in peace.
The only thing I'm concerned, Your Lordship, is that after all, it's a public money. It's a public money.
But then the thing has been done. There has
It's
to
a
be
public money, Your Lordship. There was a destruction of that is used for a public purpose by the villagers, Your Lordship. That has been destroyed, Your Lordship.
So you can proceed for damage, recovery of damages. This criminal case, if at all results in conviction, will it result in payment of compensation to you?
Lordship, that also compensation may come, Your Lordship.
So we can understand, but then it's all right.
All to
Mr.
see.
Sen, you are appearing for?
No, I am appealing for 2 and 3. Now you Lordship is taking it. So for 2 is concerned, while he lodged the first letter, because he was the wrong version of that.
Yes.
No, he is also a signatory, and he is the present wrong version.
Yes.
All of us before your Lordship, this has been amicably settled. And the main issue was might of the water shoot. That has been restored. There is no problem. And they are living amicably, might we also want to come out of it.
So it means the response number 3 is not that important so far as the criminal.
No, no, Your Lord.
Whatever, even then,
He was not a part of the complaint.
only to show my Lord that it has been restored. The wrong person, present wrong person is before your Lordship.
He's the
No
present
issue at all.
headman.
Present.
Of which village?
Umpernai.
Umpernai. Sardar Umpernai. So my Lord, it has been resolved, my Lord. Everything has been resolved, Your Lordship.
Okay. Heard. Mr. K.S. Kiji, Learned Senior Counsel. Please sit down. Appearing for the petitioners. I'm so and so along with appearing with so and so. Just assisted by so and so, appearing for the petitioners. Also, Mr. Nandi Shulai, Learned AG, appearing with so and so for the respondent number.
Yeah, respondent number.
There is no one with you, Mr. Shulai.
Lordship, Mr. Hine is
You
there,
are not
yeah.
supposed to stand alone. Anyway, so and so, and Mr. Sen, Learned Counsel, living with us on 2 and 3. The paragraph, the fact of the case. Oh, just before that, you say this is an application under section 482. Praying for washing of GR case number 93 within bracket A of 2020, registered under section 3 of Prevention of Damage of Public Property Act 1984, read with section 447, 427 and 34 IPC, pending before the Court of the Judicial Magistrate First Class at Shillong. Now, this is arising of that same FIR, isn't it? So we do not have to say separately mention the FIR. It is not required.
No, Your Lordship.
Once we say quashing of the case has resulted in these things. No, since there is separately FIR has been separately mentioned in this petition in the cause title, so that is why it's all right. Okay. Paragraph. The brief phase fact of the case is that on 21/12/2017, an FIR was filed by the respondent number 2 before the officer in charge, Madan Reding Police Station, Shillong, which was registered as Madan Reding PS case number 127 within bracket 12 of 2017. alleging that the petitioners, all the petitioners are accused, all the petitioners.
Yes, yes, ma'am.
Allegation against those, all the petitioners.
Yes.
Alleging that the petitioners alleging that on 20/12/2017 at about 7:45 a.m. No, do not give the date and timing. You just say alleging that the petitioners had come to destroy the source of water supply which was newly constructed under the Community Development Scheme 2015-16 2015-16 2015-2016 yes. Stop. On his arrival at the spot of the occurrence, it was found that the newly constructed water supply source was destroyed. It was alleged that the said construction was made by utilizing the sanction amount utilizing the sanctioned amount granted by the government. It was requested therein to take legal action into the matter against the petitioners. Stop. Upon completion of the investigation, the matter was charge sheeted and forwarded to court for initiation of criminal proceedings against the petitioners under section. Just see all those things that earlier you have said. So and so. Stop. It is submitted. The trial is pending and is at the stage of recording of evidence of prosecution witness. Stop. Give a paragraph. The learned senior counsel appearing for the petitioner submitted that the filing of the FIR was an outcome of existence of dispute between the people of two villages two different villages. Stop. Two different villages of, what are the name of the villages?
Umpernai and Lamlair.
Just read the name, get the name, and others from the petition will be getting it.
Umpernai and Lamlair.
Between the line the FIR is the outcome of the yes. The
Another thing also, my lord, it is pending for consideration of charge, not for dividend.
The trial is pending for. Before that, this early paragraph submitted that the matter is pending for. Is pending for consideration of charges by the trial court. Just consideration of charges of charge by the trial court. Instead of saying that pending for recording the evidence, just cancel it. Okay, then come to the next paragraph. We just non-senior submits that this finding of the FIR is an outcome of a dispute. Such and such villages, people of such and such villages, between people of such and such villages. Okay. The learned counsel submits that the petitioners are all residents of Lamlair village. And the complainant, comma, the respondent number 2 in this, respondent number 2, was a headman of Umpernai village. At that point of time. Who lost the FIR? The learned senior counsel submits that the entire dispute between the two villages has been settled now, and the villagers are residing without having any grievance against each other, and the resident of both the villages are residing without having grievance against each other. Stop. The learned senior counsel further submits that there was a they submit that in connection with the dispute there was a civil case, there was a civil case pending between the two villages, which was compromised and the civil case being the damage suit number 4 of 2018 was closed on the basis of the said compromise by the order dated 15 July 2022. 15 July 2022 by the court of the presiding officer, Subordinate District Council Court, Shillong. The learned senior counsel has also referred to the what is that compromise settlement? Compromise date? Page
101 your lordship.
What is it? The London Senior Council also refers to a agreement, to a deed of compromise dated 12 June 2024, entered into between the petitioners and the respondent number 2 and 3, wherein the fact of settlement between the parties have been specifically recorded. The London Senior Council, by placing reliance on the decision of the Apex Court reported in 2012 10 SCC, page 303, reported in 2012 10 SCC, page 303, such and such versus such and such. You will get it from here, okay? Submitted that as the involvement of section 3 of what is that act? Section 3 of prevention of damages to public property. It is prevention of damages to public property or Meghalaya prevention of public property?
No, Your Lordship, that is a central law.
Okay, prevention of yes. Section 3 is not compoundable. Comma. What is it? Mr. So-and-so is referred to as such and such decision and submits that since okay. That the comma the law laid down. By the Apex Court on the side decision. Maybe followed. To quash the proceeding on the basis of the settlement recorded by the parties. He prays that is no fruitful purpose would be served. He prays that he submits, he just say he submits that has no fruitful purpose would be served by allowing the criminal proceeding to proceed, comma. The same may be quashed. Stop. Paragraph. Mr. Andy Shulai, London Council. London Council appearing for the state respondent number 1. Mr. Andy Shulai, London AG appearing for the state respondents. Submits that the the action of the petitioners have resulted in causing of damages to the public property, he submits the water source which was damaged because of the action of the petitioners was constructed on the basis of the sanction made by the government. And in that view of the matter, the this view of the matter, this case is not a fit case for quashing on the basis of the settlement arrived into between the parties. However, the learned AG does not dispute the fact that the matter has been settled between the parties, written between the petitioners under respondent number 2 and 3, and at this stage there exists no dispute between them. Stop paragraph. Discussion learned counsel applying for the number 2 and 3 supports the submission advanced by the learned senior counsel for the petitioner, and also submits that the respondent number 3, who is the present Sardar of Umpirni village, also acknowledges the settlement stroke compromised arrived between the parties, and does not want to see that the dispute is carried on any longer. Stop. Here paragraph. A perusal of the record of the present criminal petition and the supporting document makes it crystal clear that there was a dispute existing between the two villages between the Lamliar village and, instead of saying two villages, and Umpirnai village. Stop. It is also clear that the allegation of damage of the water source has had also resulted in from the rivalry between the two villages, between the two villages. There is no dispute to the fact that the villages at present, the villages, more particularly the petitioners and the respondent number 2 and 3 have now settled the difference between them and have decided to compromise the matter, based on which the damage suit number 4 of, what is that number you just see, was closed. The deed of compromise, appended to the writ petition also makes it amply clear that both the parties have decided to bury their differences and amicably resolve all the issues pending between them. Stop. Give a paragraph. The case law cited by the learned senior counsel speaks about the authority of the High Court to quash a criminal proceeding involving non-compoundable offence in view of compromise arrived between the parties. In the said case, the apex court has laid down that the High Court would be empowered, laid down that under section 482 CRPC, the High Court has the power to quash a criminal proceeding on the basis of a settlement. Arrived in between the parties in non-compoundable offence. Legal paragraph. In view of the law settled by the Apex Court, in the facts and circumstances of this case, this court is of the opinion that the parties have now settled the difference between them, and there is no mention of existence of occurrence of any recent dispute between them. Of no useful purpose would be served if the trial is allowed to proceed. Stop. Having regard to the nature and gravity of the crime, nature and gravity of the crime, and more particularly in view of the fact, more particularly in view of the submissions made by the petitioner and the private respondent, that the water resource is at present functioning fully, and there exists no grievance between the parties with regard to the same. It is deemed appropriate to quash the further proceeding of such and such case, so whatever is mentioned in the beginning. Okay. Accordingly, the entire proceeding of the aforesaid case stands quashed, the criminal petition stands allowed. Yes. Yes, all them.
Offline.
There will be some correction. You will just.
Yes, yes, sir.
Obviously, there will be.
The list of date also is there, very much. The list of date is very much there in the petition also.
Yes, so let maybe you see sometimes it happens, and
yes,
we also commit mistake while writing. Sometimes there is a repetition and all, so we'll just correct it and.
Okay, madam. Right.
Second call.
Offline.
Supplementary cost list, item number 1.
Yes. Yes, what was your submission? Yes, Mr. Jha.
My lord, mentioned on the 2 occasions, my lord,
You didn't appear
I
on
was
18/9.
absent.
8/9, it was dismissed.
My lord, on the ground that on 27th I was undergone cataract surgery, my lord. On that ground, I was absent, my lord.
Okay.
On the medical ground.
We are passing order. We will not wait for him. Yes. Yes, heard, Mr. Arja, Learned Counsel.
Your Lordship,
Yes. Why you are so, when we are starting to dictate the judgment, why you are speaking in the middle?
Your
Yes,
Lordship,
what do you want to say?
Your Lordship, I have no instruction. Your Lordship, as the DSGR, he has
Huh?
some submission to be made.
See, we have given time. You see, at the beginning you mentioned it. We have kept, just because of your request, we have kept it at the end of the day.
Yes, Your Lordship.
So when the matter is called, see, counsels are expected to be here.
Your Lordship, if Your Lordship can allow us if this matter may be taken up on Friday, Your Lordship.
Your Lordship,
Yes.
I am at the mercy of this honorable court, my lord, because the
No,
petition.
do not say at the mercy of
My
you
lord,
have filed a petition under law. What is the question of mercy, Mr.?
my lord, I have filed
Court
stating.
doesn't show any mercy.
My
Court
lord.
passes an order in accordance with law. You come to the court and you say, this is my right. Yes.
Since the matter, my lord, can be restored and can be heard on the next week, I am ready, my lord. The petitioners are ready for.
We'll have it on Friday then. Or next week. Maybe what do you want?
My lord,
Right.
Friday, my lord, because urgency of the matter is there.
Just say. The request made on behalf of the respondent, list this matter on. Give Friday's date. Yes.
Lordship, Lordship.
No other matter.
Number 2 is the same, my lord. 1 and 2 are.
How
the
many
same.
petitions are?
2 petitioners, my lord. Separate, 2 petitions.
So separate.
My
Two separate petitions. But then what objection you can have at this stage? In the same order, there also.